Before this case even begins, you can feel the tension brewing. A landlord, a tenant, nearly $7,500 in alleged back rent, claims of bug infestations, electrical issues sending bills to $600 a month, and repairs totaling thousands out of pocket. But here's the twist: this isn't just about unpaid rent. This is about whether the right party is even standing in court. You've got Henna and property management listed as the plaintiff, but who actually owns the property? Is it a person? A corporation? And if it's a corporation, can someone just walk in and represent it without an attorney? Spoiler alert, that's where things start to unravel fast. Meanwhile, the tenant, Lita Boone, who goes by Lita, saying she fell behind because she had to pay for pest control, patch a massive patio hole, fix appliances that should have worked from day one, and deal with an electrical issue that allegedly spiked her power bill from $150 to $600 monthly. That's not a small oversight, that's a serious financial burden. So the big question is this: is this a simple back rent case? Or is this a breakdown in landlord responsibility that spiraled into legal chaos? And even more importantly, did the plaintiffs ignore a direct judicial order? Stay locked in, because what starts as a payment plan negotiation is about to turn into something much bigger, something that could have criminal implications.
Court does call the case of Henna Realty and Property Management versus Lita Boone.
I'm here, Lita Boone.
Lita. Oh,
Lita.
Lita. Okay.
Yes.
You were just waiting to unmute to yell at me about that, weren't you?
I can
No, it's okay. It's okay. I got thick skin. I'm sorry, Lita. All right, now, where are we, Mr. Pantera, on this case?
This is not mine.
This is not yours. Whose is it?
This is the matter where they've been instructed to get counsel, Your Honor. And
Where Henna Realty's been instructed to get counsel?
Correct. Mr. Joseph Courtroom, I believe,
Is he?
the owner.
Yes,
of-
Joseph is here.
Yeah.
Mr. Courtroom?
I'm the property owner.
Yes, sir.
Yes, sir.
But this is in the, it's a corporation that owns this property, right?
No, the corporation is my property owner acting on my behalf. I am the property owner.
And your name is correct. I don't have this filed as that. I have this filed under the name of the property of Henna Realty and Property Management.
Yes, because they represent me. Michael, yeah.
But the lease is between who and who?
Between Hannah Property Realty and Lita.
So my understanding is Judge Washington has instructed that you are to have an attorney represent the plaintiff in this case.
I thought she said we should reach an agreement and bring it to her.
Well, certainly that can happen, but if you are going to appear for another hearing, it's very clear to me that you guys were instructed to get an attorney.
When we said we didn't have an attorney, she said, she put us in a different room and said we should go and discuss it and come with an agreement.
Certainly. Do you have an agreement?
Yes, we do.
Ms. Boone, is that correct?
yes.
All right. What is the agreement?
Michael, would you please read it out?
Well, okay. That's the property.
Well, I can read it out. I can read it out.
Yeah, well, you'll have to, because the property manager can't legally represent this corporation.
Okay.
That's who wrote the contract
Wrote what contract, ma'am?
that he's going to read out to us. The agreement.
Okay. What is the agreement?
That the agreement is that I don't owe the 9, I owe 7,000. I think, and I don't have it right in front of me, and
I can
that
give you the figures.
And
As at October 1st, she owed 7,449 and 58 cents. The agreement was that she would start paying $500 a month, and she has already started making the payments, $500 a month. And then from November 1, she will make her regular monthly payments in addition to paying the back rent of $500 a month until it is paid off.
Let's pause here because this is where the numbers matter. As of October 1st, the alleged balance is $7,449.68. The proposed agreement, $500 per month toward back rent, plus regular monthly rent starting November 1st. That's significant. If her rent is $1,800, as she later mentions, that means she'd be paying $2,300 a month minimum to catch up. Now here's the legal nuance. Repayment plans and eviction or rent disputes must be crystal clear. Due dates, total balance, default consequences. Notice how the judge immediately asks, what day is the $500 due? That's not random. That's about enforceability. If it's vague, it's unenforceable. And when Lita pushes back, saying the $500 should be due by the 15th instead of the 1st, that's actually reasonable negotiation. Courts often allow structured repayment plans that reflect ability to pay, but here's what I want to know. If she truly couldn't afford it before, is stacking rent plus $500 realistically setting her up for success or setting her up for failure? What do you think?
Okay, what day is the 500 due?
She has already paid the first one.
Okay, but the subsequent month, what
It's
day
due-
is she supposed to pay the 500?
It's on the first of each month.
So she's got to pay her rent and 500 on the first of each month?
Yes, please.
The only way I'm signing it is the 500's got to be due by the 15th. If it's going to happen, there's no way somebody's going to be able to do that. Otherwise, she wouldn't be here.
And also in the contract, you stated, ask me how much I'll be able to pay. We never set a date. And today now you saying I need to have the 18 and the 500. That's not in the contract that you sent me. So I'm confused right now.
Okay,
Okay,
I'm not sure what contract we're talking about.
We will agree to the 15th, Your Honor, the 500 by the 15th. So let's put that on record. In addition to the normal rent, which is due on the first of each month.
Miss
I don't.
Miss
I
Boone,
don't.
is that what you agreed to? What?
Well,
Tell me
we
what you
went into a Zoom room. I thought everything was unfair, but they said that this is the way it is. So I don't have no more fight in me. So
All right, hold on. So Miss Boone,
yes,
just tell me this. So you don't want to agree to this?
I don't want to be.
Well, okay, go ahead. What were you going to say? I'm sorry, I didn't mean to interrupt you.
I'm just agreeing to it.
Well, hold on. Talk to me, okay? I wouldn't ask if I didn't care.
It's just give me a second. So in the Zoom room, we had made a meeting. His property management told him that it was things in here that I spent a lot of money on paying to fix up this place. Well, first of all, I moved in unaware that it was infested with bugs. So I took care of that problem. So he did pay me back for that. And then I noticed like 2 weeks later, I had moved a barbecue grill and it was a big hole in the patio. So I paid like $1,500 to fix that. The washer and dryer and stove and refrigerator that came with the house didn't work. So I had to fix it. So that made me get behind in the bills. And then he just came and fixed the electricity and my bill was going up. It was $600 every month and I'm by myself. And I'm like telling him that it's a problem with electricity. And he just came and fixed it 2 weeks ago. And you can notice my bill went back down to $150.
Okay, now this changes the tone entirely. We're no longer just talking about unpaid rent, we're talking about habitability, If a property is infested with bugs at move-in, that's typically the landlord's responsibility. Same with major structural issues like a patio hole or non-working essential appliances. In most states, landlords have a legal duty to provide habitable living space. If those appliances came with the lease and didn't work, repairs generally fall on the owner, not the tenant. In the electricity claim, a $600 bill dropping to $150 after a repair suggests there may have been a legitimate issue. That's not a minor fluctuation, that's dramatic. Now here's the key legal concept. If a tenant pays out of pocket for necessary repairs after notifying the landlord, sometimes they can deduct those expenses from rent, but it must be properly documented and legally handled. So was Lita improperly withholding rent? Or was she trying to offset costs she shouldn't have had to pay in the first place? This is where landlord-tenant law gets messy and where documentation is everything.
Instead of $600 a month. So I've been paying him every 2 weeks that I can and stuff. And then one check he said he never got, but I just been paying him and paying him, trying to catch up. And I couldn't never catch up. So I told him, let's go to court and get this settled, because I'm constantly giving you guys all my money and it's looking like I'm never catching up and I don't know what's going on.
So what it sounds like to me is there was not an agreement when you guys came out of that Zoom room.
The agreement was that he would take off, because he said I owe $9,000. So he took off the Orchid bill and
The Orkin bill.
yes.
Is that the pest bill?
Yes.
Why are you paying that anyway?
Because he said his property manager said that I didn't report to him that it had a bug problem. And then when I talked to Orchid, they said it was already a bug problem here. So I just paid for it. I didn't know I work a lot. So I just want to live nice and comfortably. But for $1,800 a month.
I hear you. But, well, that wasn't going to be on there anyway, or shouldn't have been on there, because that's typically it's going to be the landlord's responsibility.
He said since I didn't inform him with these problems, which I did. So
okay. All right. I'm going to stop this right now. Sir, my understanding is Judge Washington told you guys to get an attorney.
We told him we will try and get
Did
it
Judge
settled.
Washington tell you, sir, don't play a word game with me. Did she inform you to get an attorney?
Yes, but then she said
hold on, and you showed up today without an attorney.
Sir, if I can answer, may I answer, please? She put us, when we said we didn't have an attorney, she put us in a Zoom room and said, go and get this settled and come back. And when we did, we asked Lita, would she be able to afford an attorney? She said, no. So we actually went through all this with her, and we thought we had an agreement. We signed the document.
You don't understand something. You have to have an attorney because it's a corporation that the lease is signed with. The lease is between a corporation and Miss Boone.
Now we've hit the turning point. This is no longer about bugs or back rent. This is about legal procedure. The lease is between the tenant and a corporation. And here's the rule. A corporation is a separate legal entity. It cannot represent itself through a non-attorney officer or property manager in court. In many jurisdictions, that's considered unauthorized practice of law. The judge isn't nitpicking. This is foundational law. If Judge Washington previously instructed them to obtain counsel and they showed up again without one, that's a serious procedural error. Courts don't treat that lightly. When the judge says this case ought to be dismissed because they're attempting to represent a corporation without an attorney, that's not dramatic flair. That's legal compliance. So here's the big question. Did they misunderstand the judge's instruction? Or did they gamble on showing up without counsel and hope the agreement would slide through? Because that gamble is about to cost them the entire case.
The lease is between you and the corporation who filed this. However it got filed that way, has to have an attorney.
Yes, Your Honor. This is Henna Realty and Property Management, Michael Henna. Yes, when we were in there, the judge advised that because I had put my name on there
Then why are
and
you guys here without an attorney?
okay, well, can I finish, sir? The Your Honor, she said, okay, she asked the tenant, Lita, did you seek out counsel? And she said yes, but she didn't qualify. So she would have to obtain her own attorney. So then the judge told both parties, look, y'all need to work this out. You need to come into some type of agreement. And she put us in the room. So we went in the room and we came up with agreement. I mean, we stayed there for hours. And what Ms. Boone is talking about, which I know is really kind of like irrelevant, the orchid, when she said, I said, we paid for the first remedy of these bugs. And I guess she reached back out to them and said they didn't do it right. And they told her something in which she had to pay more money and had her paying $300 a month or something on some type of contract with them. And I said, Lita, why come you didn't tell me about this? I said, why you didn't tell us so that we could deal with them? If you saying they didn't do it right, but you enter into a contract with them without our knowledge, that's not the owner's, responsibility. So that's what we
Mike,
got to do
you
with the
told
orchid.
me, Mike,
Well, we came up with the
that
number.
morning, I'm sorry to interrupt you, but the morning that I woke up and it was infested, I told you, look on my other phone number. I told you, you told me to call Orchid, but now you don't remember.
But we paid for that. We paid for that.
But you just told the judge that I didn't give you no knowledge of what was going
Not on
though.
the second
That's
time.
what I'm
No,
saying.
the
You're
second
confusing
time.
me.
No, wait a minute. Don't be confused because you the one told me. I didn't know nothing about it. We was wondering why was you paying $300 a month? You told me you paying all this money. I understand your daughter got in problems. You was getting garnishy. But what I'm saying is
I
about
don't
this
have any
about,
garnishes,
Stop
sir.
right
I don't
now.
have no
about the
garnishes.
orchid, about the orchid thing.
Stop. Stop. What part of stop don't you understand?
Notice how quickly the tone shifts once the judge steps in firmly. When the property owner starts bringing up Lita's personal financial struggles, garnishments, family issues, the judge shuts it down immediately. That's courtroom control. Courts are not a place to air personal grievances or attempt to sway the narrative emotionally, especially when procedural compliance is already in question. And then comes the bombshell. Representing a corporation without an attorney could be treated as a felony in some jurisdictions. That's serious. The judge is essentially saying, you were warned. You didn't comply. I'm not risking it. This isn't about who owes what anymore. It's about whether the plaintiffs followed court instructions. And when you ignore a direct order, judges rarely give second chances without consequences.
I'm not having it. You guys are supposed to show up with an attorney. You don't have an attorney. Of rights, this case ought to be dismissed because you can't represent the corporation. That's what the judge told you before. And I'm not going to have you going around and around with Miss Boone and trying to throw her business out in the street and say she's got this and that. Not going to happen here. Not today. Judge Washington gave you the warning. I understand it, that you were supposed to be represented by counsel. She may have put you into a room so that you guys could agree to it. My understanding in listening to Miss Boone is that she has not agreed to something, or at least feels that she's coerced in doing so. You guys don't have an attorney. You keep trying to represent yourself. If you want to go ahead and commit a felony, because it's a 4-year felony for you to be representing a corporation, if you want to do that, you go ahead. You're not going to do that on my watch. Case dismissed. You can start over. Thank you.
And just like that, the case is dismissed. Not because the rent dispute was fully resolved. Not because the numbers were sorted out, but because the plaintiff corporation appeared in court without proper legal representation despite being instructed to obtain counsel. Legally, the judge's decision reinforces a critical principle. Corporations must be represented by licensed attorneys. Procedure matters. Structure matters. And ignoring judicial instructions can derail an entire case. As for the tenant, this dismissal doesn't erase the disputed. Simply means the landlord would need to start over properly, likely with an attorney, if they want to pursue the claim again. So, what's your take? Was this a landlord trying to collect legitimate back rent who made a procedural mistake? Or a tenant overwhelmed by repair costs and unfair pressure? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.